There we go. Good morning, everybody. Welcome to our November webinar. Can you believe that it's November already? I most certainly can't. On the one hand, I'm quite sad that the year is coming to such a very quick close. But on the other hand, I'm more than excited for the 15th of December, which is my last working day, only coming back towards the far end of January. So very, very much looking forward to that break. Peter, yes, that's amazing. This morning, we're very fortunate to have Peter join us. Peter Mennen is from Trafalgar. Carl will be doing a nice introduction on Peter, but I've recently spoken to one of Peter's colleagues, and they were very complimentary of Peter, saying how nice it was to work with him and how friendly he is and how knowledgeable he is. So I'm very glad that we've got him as our co-host today. As I mentioned, the session is being recorded. The recording will be shared on our website along with all of Peter's information. Peter's got a very interesting topic to share with us today. But without further ado, I'm going to be handing over to Kyle from our offices, and Kyle will do a nice welcome and introduction for us. Kyle, over to you.
Thanks, Linda. Right, good morning, everyone. I hope everyone is doing well and is excited to listen to our discussion on POPIA and PPRA. This webinar, as Linda said, will be recorded, and it's also going to be published to our YouTube channel. So please remember to like and subscribe to our channel. If you haven't already, please do sign up to our newsletter. This way you'll be able to keep in touch with TVDM consultants, as well as the latest Nicole's Neighborly Advice videos. I'll also post the relevant links in the chat to that. We would like to say a special thanks for those who commented and took part in our Halloween competition. Keep your eyes on our social media, please, as we will be posting a Black Friday competition soon. So more details for that to be announced next week. Then our last webinar for the year will be on the 8th of December. So information will also be coming soon for that. And then also, as Linda said, if everyone can just stay on mute, that would be greatly appreciated. I would now like to introduce and welcome our guest speaker, Peter Mennen. Peter Mennen started his legal career in a niche property law firm in Johannesburg in 2011. His focus was predominantly in eviction and rental claims for rights, as well as sectional title collections. During his stint as a director, he was able to secure the first utility disconnection application on behalf of a body corporate on a non-paying owner with a tenanted unit. Peter then joined the TP in Credit Bureau as head of legal for 6 years, wherein he engrossed himself in compliance and data privacy law, drafting, training, management of client relationships, and then also legal departments, data collection, negotiation, and general counsel duties. Peter now continues his legal property journey at Trafalgar Property Management in the head of legal and marketing position. Peter loves mountains, reading classic fantasy novels, and spending time with his family. As an avid ultra trail runner, he has also completed 200-kilometer races and plans to do his first 100-miler in 2023. Right, thank you. I'll post all the necessary links in the chat.
Not the stuff regarding classical fiction, hey?
Gee whiz, I'm exhausted just listening to how many kilometers you run. Over to you, Peter.
Thank you very much, Linda. Thank you very much, Carl. Really fantastic morning to everybody. It's such a topical conversation that we're having today, and I'm going to try and keep it as a conversation. So, Linda, please interrupt and ask questions. Carl, yourself as well. It's so topical, and the reason for that is because we've recently had the finalization of the Practice Directive on Protection of Personal Information and Access to Information Act from CSOS. So this was in the draft format, and it was probably directed to us about 2 months ago, in which they spoke about the compliance of what a community scheme must go through in relation not just to POPI, but into PIA as well, and the interaction between the Sectional Title Schemes Management Act, the prescribed management rules, as well as POPI. Carl, I apologize, I'm not going to call it POPIA today. I'm moving out of Pretoria over the next week, so I'm not going to call it POPIA. We're going to go on POPI, and we're going to speak about POPI today. And also just the direction that they're sort of taking when it comes to consent requirements. Unfortunately, when it comes to this conversation, I don't have a crystal ball. So I can't tell you exactly how they're going to interpret this, how the information regulator is going to interpret this, as well as certain of the gray areas that's been created by this new practice directive that they've actually put out. There are a number of gray areas. Zelinda and I had a quick conversation before this webinar just about some of them, which we are going to pinpoint to you today. But hopefully throughout this presentation, I'm going to take you through some tips, perhaps to get yourself compliant, not just as a body corporate or rather a community scheme, but also as a managing agency. Because as you all are aware, it's not just the community scheme that needs to be compliant when it comes to this piece of legislation, POPIA and PPRA, but also the managing agency. And the managing agency's compliance is vitally important. One of the things that we've been discussing internally over the last 8 months since me joining Trafalgar is the reputational risk when it comes to a breach of personal information. What we try to do through the trainings as well to all our portfolio managers and portfolio administrators is to indicate to them, yes, there are these fines and let's call it imprisonment that has been documented through the piece of legislation. But the thing that you're actually sitting with when it comes to breaches of personal information, whether it be from a body corporate or homeowners association perspective, any other community scheme, as well as the managing agency, is the reputational risk. You don't want to be known as the managing agent that gives out information that they shouldn't be giving out, or protecting the data or personal information from the data subjects in a manner that is not compliant with a piece of legislation. The majority of breaches when it comes to POPI is not nefarious third parties wearing a hoodie or a flat cap sitting behind their computer and trying to hack your system through phishing and spear phishing and all these different terms that the cybersecurity experts have now coined. It's usually from a scenario of internal negligence. Usually it's internal negligence. And in certain instances, it can obviously be intent. An ex-employee stealing a database worth of information, but usually it's a data breach that relates to negligence of an employee or a person sending out information to a scheme or to members of that scheme that should not actually be sent out. So I want you to keep that in the back of your mind throughout this conversation. We are going to touch on a lot of the legal points. I apologize. I am going to go through the legislation. I love reading legislation on a Sunday evening with a glass of wine. It's fantastic. It's my favorite thing to do. So Linda, you're just going, no, it's not.
No. A glass of wine, yes. Sunday evening. No.
But I am going to go through the legislation because I think it's important when you do certain things, specifically when it comes to compliance, is to keep in mind that strict compliance is necessary. As much as you try to sort of filter through as a compliance officer, information officer, through the whole rigmarole and jumping through hoops of the legislation and what they've actually put in place, there is a very strict compliance procedure when it comes to POPI. Luckily for us, and just to give you some background on the Protection of Personal Information Act, we don't have to deal with, in the majority of instances, the GDPR, the General Data Protection Regulation from the United Union, which is specifically related to European Union citizens. If it relates to a European Union citizen, then you're actually going to have to be compliant with the GDPR as well. But luckily, our piece of legislation, POPI, is a, let's call it a diminutive form of the GDPR. The GDPR does set out quite a substantial amount of other regulations that you need to deal with. One of those things that does come to mind almost from the get-go is cross-border transfer of information. So before I actually get into the legislation, this is one of those like stickler points that I always deal with within webinars and try to speak to clients about as much as possible. Marion, I promise you, I'm going to speak about the new CSOS practice directive and go through it in detail with you today. Is that the cross-border transfer of information could actually lead to a lot of problems. So I want you as the managing agent to go and have a sit down and have a look at who your service providers are. If you're utilizing platforms such as Zoom, different service providers, different data providers, remember that their servers sit in different countries. So as soon as a service sits in a different country, you do have that cross-border transfer of information. and it actually needs to be included in your own, they call it a POPI manual, but I'm going to discuss that today in depth as well. And needs to be included in your data transfer agreements with those single suppliers, because then other pieces of legislation for other territories might actually come into play as well. If you're using different CRM systems, perhaps you're sitting with Fresh Sales or PowerDesk or whatever it might be, then you're also going to have to sit with those data processing agreements with those individual suppliers and make certain that those servers sitting in the different countries are actually compliant to POPI or whatever piece of legislation that they have to regulate. Before I bore you too much on a soliloquy, let's get directly into this CSOS practice directive. Let's discuss it. If you've got any questions, Linda, please interrupt me. I love to get interrupted while I speak. I really don't mind. I can keep my train of thought. I take notes.
And I love interrupting, so we're a perfect match.
Lovely. I'm sure this is one of many webinars that we'll do together. Yes, please. I will
share the practice directive on the chat, but it is widely available as well, and we'll put it as part of the recording of the session too.
Excellent. Thank you very much. And Linda did ask me if I had slides prepped. I don't. The reason being is that I hate death by PowerPoint. So I'm going to try to keep you entertained with my face and with Linda's face. So let's get stuck right into this. Okay. So just as a starting point, we're going to speak a little bit about terms and definitions from the get-go. I think it's important that we get going on this so that everybody sort of understands where we're coming from when we speak about things like data subjects, responsible party, community schemes, etc., because they do all have definitions in terms of these pieces of legislation. So a data subject, when it comes to this, is any natural or juristic entity. So that means a individual party, a person with an ID number, a person with a passport number. Also companies fall under the definition of data subjects, and also into the corollary definition of personal information. That does actually fall into that as well. So when we're talking about data subjects, we're talking about any person that has a involvement in the scheme, has an involvement in your business, including managing agents and their employees, would also fall under the definition of a data subject. So it's a very broad definition of the specific party that we're dealing with. And data subjects have something we call personal information. Now, to deal with personal information, because we're going to go through the CSOS practice directive and we're going to link certain portions of personal information throughout this chat, it's important that I actually go through the definition of personal information for you. Because the majority of people, when they think about personal information, they think it's only things like ID numbers and passport numbers and email addresses, and let's call it physical contact information, when it's actually a very broad definition. And it does segment itself into what a scheme, what a HOA or a body corporate does collect on parties, including things like biometric information. So having a look at personal information, it's an identifiable is a very strict term over here. It means you need to be able to identify the data subject through form of a name, ID number, address, etc., IP addresses even in certain instances. Like we said, natural person, juristic person falls under this context, and it includes information on race, gender, sex, pregnancy, marital status, national, ethnic, or social origin, color, sexual orientation, age, physical, mental health, well-being, disability, religion, conscious belief, culture, language, and birth of a person. It also relates to education, medical, financial, criminal, or employment history of that party specifically, any identifying number, symbol, email address, physical address, telephone number, location information, online identifiers, IP addresses, or other particular assignments to that person. Biometric information, we have this question very often with regards to security cameras, etc., which we can discuss today if you'd like. Personal opinions, views, or preferences of that person, correspondence sent by that person that is implicitly or explicitly of a private or confidential nature, or further correspondence that would reveal the contents of the original correspondence, views or opinions of that person, or even views or opinions of that person by another party, if it's confidential in nature, of course, and then the name of that person as well. So you can already see the amount of information that you as a managing agency or data rather, let's just group that in data, personal information, that you as a managing agency or as a individual community scheme is actually capturing is massive. It's huge. And where you're storing that information is vitally important as well. I will take you through the 8 pillars of lawful processing in terms of the Act. I think it's important that we get stuck in over there to see exactly how and what you should be compliant with when it comes to this piece of legislation and the interaction between. Because like I said, there are a couple of gray areas that is created, but hopefully through certain sections like Section 11 and Section 18, which does include certain exclusions, we can call them that, or exemptions. When it comes to compliance, these do sort of fit into those categories for those gray areas. Processing is also a very important term. Processing is not just the dissemination. So it's not just sending out of information. So just having a look at the definition of processing, it includes collection, receipt, retrieval, alteration, collation, storage, updating or modification, retrieval, alteration, consultation or use, dissemination, sending out by means of transmission, distribution, or making available in any form, merging, linking, as well as restriction, degradation, erasure, or destruction of that information. It's a huge list. When we're talking about processing of personal information, we're not just talking about the keeping, safeguarding, storing. We're talking about all those intermediary steps as well, including the changing and alteration of that information. Now, perhaps a good stopping point before we get into further definitions is, I'm sure you've all heard about Section 69 of the Act that deals with direct marketing. Direct marketing is a very interesting concept because it really deals with what you can and cannot do. Carl, you guys are fully compliant. So glad to see that with your unsubscribe buttons, etc. But it does really relate to the direct marketing practices. Now, one of the discussions that I've had previously was with the Direct Marketing Association of South Africa. And what they also included is when they spoke to the information regulator, the regulator of POPI, is that they also said that businesses should not go out of business as a result of this piece of legislation. You just need to be compliant when it comes to sending out of marketing material first time right, meaning that you can market directly to parties through your managing agency, but you need to get it right the first time, meaning that you need to have an unsubscribe list. You need to give the parties the option to unsubscribe directly from your mailing list, but also you need to get the mailing lists from a sourceable, verified, let's call it intermediary third party. So one of the discussions that's always had is with the state agencies and how they get information and through what medium they're actually getting contact information. But I'm going to leave that there. Section 69 is a whole rigmarole. I can have a half an hour discussion just on Section 69. But if you want to ask me any questions regarding Section 69, you're more than welcome to do so as well. So with regards to the objectives set out in the practice directive, it's obviously objectives that outline what POPI is actually supposed to do with regards to protection of personal information of data subjects. So we're not going to go through that. You can read it yourself, but it really just relates to this is the objective of protecting information of individual members of that scheme or employees of that scheme specifically from any intervention by third parties. The legislative framework, and now we need to really speak about this, is that there are multiple pieces of legislation that regulate sort of the same thing. We're going to talk about the interaction of Prescribed Management Rule 27, as well as the interaction between POPI. But if you're looking at this, PIA does a lot of similar things than what POPI does. POPI obviously has this interaction with the Sectional Title Schemes Management Act, with the Constitution, with all of the different Community Schemes Act, your Share Blocks Act, etc. So you need to read these in conjunction. You can't just go, POPI says this, and as a result of this, we can't do or we can do. You need to look at them together. The term is holistically. You need to look at this legislation together, all of them. Okay, not even going to go through the scope, and let's just get really stuck into the nitty-gritty of protection of personal information. So when we're dealing with Section 11 of POPI, this is probably your most important section because it deals with when a person may process personal information of a data subject. And there's very distinct instances when a person can actually do so. The only instances that you can process personal information as a scheme, as a managing agency, is number one, if consent has been granted by the data subject or a competent person, meaning that if there's a minor, the parent or the guardian has consented to that information being shared. There's also a lot of other restrictions when it comes to processing of personal information of children, which we're not going to go into today in detail, but just remember in terms of that, in terms of POPI, there is certain conditions that need to be met with the processing of personal information on children. This may come into play with security cameras, whereby you're storing biometric information of children as well. Processing is necessary to carry out the actions for the conclusion of performance of contract. Very important for managing agencies, because we've got a contract that determines that we need to keep certain information and process information from the data subjects. Your contracts need to have a POPI clause that speaks to the data privacy, and perhaps even sharing your own POPI manual with those individual schemes is a good way to go about it, to ensure that they and you are compliant when it comes to data processing. Processing complies with an obligation imposed by law on the responsible party. And this is a very important condition. It's a very important exclusion. Because we've got the Sectional Title Schemes Management Act, specifically the prescribed Management Rule 27, dealing with what information may be kept, or must be kept rather, by that individual scheme, you've got a piece of legislation already directing the scheme to keep information on data subjects. So you've already got the exclusion over there that they may keep the information. But remember, processing is not just about keeping or storage. It's about dissemination and what you actually go and do with that data. Processing protects the legitimate interests of the data subject. Processing is necessary for the proper performance of a public law duty. So a good example of a public law duty would be something like the deeds office. The deeds office needs to store information on property transactions, who owns property, where it's been registered. It's a public law duty, so all of that information is public domain information, so you can actually purchase that information through the deeds office or through other service providers and credit bureaus. And then processing is necessary for pursuing the legitimate interests of the responsible party or a third party to whom the information is supplied. Now, all of these different conditions in section 11 is an or condition. So you don't need to comply with all of them. It's or. So you can comply with one or hopefully not none, because then you can't process the personal information. But the most important one in my mind is consent. Consent is vital. Consent is always one of those things that I harp on. Rather get consent than not getting consent. Because if you've got consent, you know that you're covered. If you don't have consent, you're sort of going to have to bank on other exclusions, including things like the contractual exclusion or the legislative exclusion. But vital is consent. And consent is dealt with in a number of ways in terms of this practice directive that we'll speak about now, and the gray areas that it's created as a result of them including and excluding certain forms of personal information directly through this. Okay. Now, just having a look at the 8 pillars of lawful processing in terms of POPI before we move further. We've talked a little bit about section 11, all of those exclusions that are created. But the pillars of lawful processing in terms of POPI is vitally important, because we don't just need to comply in a singular instance with, let's say, for example, the consent requirements, all those requirements in terms of section 11. There's a number of different requirements that actually come up. Now, if you're dealing with this, when you are lawfully processing any information on a data subject, their personal information, number one, you need to look at accountability. Who's accountable for that information and the processing of that information? Is it only you, or is it a third party? And do you have the agreements in place to ensure that everybody's compliant in terms of the Act? Processing limitation, which means that you can only process certain information for a limited purpose. So let's say, for example, you want the information because you need to, in terms of the legislation, keep that information. That's a specific purpose. You can't go and process that information with outside or ultra vires, without the law, outside of that scope of the law, in any instance without the consent. Purpose specification. Ooh, sorry about that. Questions? No, Zerlinda? Can I carry on?
Sorry, I just got distracted with that noise quickly. I muted it.
No problem.
I know that you are going to talk about the whole consent element when it comes to the CSOS practice directive. And I think everybody's sort of like holding their breath until you get there. But, you know, sometimes it's very, I want to say sometimes it's impossible to get people's consent. If you think about the access to information for the calling of a meeting, for example, if I'm a managing agent and I get asked by an owner for all the owner's contact information, and I email all the owners to say, may I please give your information out, or will you please contact this owner? You know, 110 of them are going to come back saying, oh, while I have you, I've got a question about my levy statement or my rules or about the next meeting, or what does this person want first, or can I get this guarantee? It's completely impractical. I know that we're probably on exactly the same page when it comes to the CSOS practice directive, so I'm going to reserve my comments until we get there. Then you'll have to shut me down because I've got quite a few.
Let's just luckily say section 4.4 of this practice directive has set it out perfectly. Let's actually get into that. Then I'll go through the other sort of 8 pillars. So in terms of 4.4, in terms of this practice directive, in the context of schemes, and remember, schemes is defined as HOAs, body corporates, etc., in terms of the CSOS Act. A member of a scheme is deemed by virtue of ownership or occupation of a unit within a scheme to have consented to his or her personal information being stored and or shared with the relevant parties by the Board of Trustees or any governance structure of a scheme for the purposes of managing the affairs of the scheme. So by virtue of ownership or membership, that party has consented. It's just created a little bit of gray area when it comes to certain, let's call it financial positions, which we're going to discuss later. But by virtue of ownership, they have consented already. So just quickly going back to this purpose specification. So you need to collect the information for a specific purpose. Further processing limitation, you can't process further than what you've asked to process. Information quality, it needs to be at a certain standard. Openness, so if a person asks you whether you are holding information of them, you need to be open about it and transparent. Security safeguards, which is a massive thing, specifically with regards to penetration testing and storage of the information, and then your data subject participation, which is obviously your consent requirements that we've just discussed in terms of 4.4. So just going back to 4.4, like I said, consent has been, let's call it tacitly given by that individual party, purely by their membership, ownership of a unit in that scheme. You can think about it in a practical way. It would be impossible to run the scheme as a trustee or a director if you didn't have people's contact information. It would be completely impossible. And like I said, with that discussion with the Direct Marketing Association, POPI made it very clear, or at least the information regulator made it very clear. The Act is not supposed to stop us from doing business. It is not supposed to stop us from complying with other pieces of legislation. It's supposed to protect individual data parties or data providers, data subjects, personal information from being nefariously used by other people. So I'm sure all of you have these wonderful marketing calls that you get on a daily basis of people contacting you about insurance and these new deals that they want to put through to you. We're actually supposed to be protected from that, but we don't feel very protected, do we? Okay, because people are still contravening the Act left, right, and center when it comes to this. But it's not supposed to stop business. It's not supposed to stop business as a managing agent. It's not supposed to stop business as a scheme for the directors or the individual trustees. Okay. So interestingly, in terms of 4.5 as well, the processing of information of a member of a scheme must only be limited. That's where you've got this purpose limitation for the management of the scheme, such as collection of levies, compliance with scheme rules, maintenance and security of the scheme. So that's where it comes in that purpose specification. We've got a special purpose in terms of the legislation, whether it be the SDSMA and the regulations there to collect information, store information, and to process that information specifically to manage the scheme. So it will all fall under that purpose specification. Now getting to 4.6, Linda, you've shared this with everybody. Hey, so they're going to have some bedtime reading tonight.
Yes,
excellent.
I have done so.
I want you all experts in the practice directive. is that everybody, or rather the schemes, need to develop something they've called a POPI manual. I hate the term completely because there's nothing in the legislation that requires you to have a POPI manual. It's non-existent. So I don't know why they've actually included this. But a POPI manual would basically be a set, let's call it documentary proof of policies and procedures that the scheme must follow with regards to processing of personal information, storage thereof, giving it out to members, etc. And also what would happen in an instance of breach. Section 22 of POPI deals specifically what must happen if information has been shared that should not have been shared. And just to quickly stop on that point, in terms of Section 22, you need to notify the individual data subject that their information has been breached, but also you need to send a specific report to the information regulator that specifies what information has been breached and who has been affected by this, as well as the steps taken by the responsible party, the scheme or the managing agent, in ensuring that this does not happen again, and ensure that the data that has already been sent out is now protected, or the parties have been requested to delete that information. Okay. In terms of Section 4.7, and I'm going to really read this because I think it's very important for everybody to get this right from the beginning. Sharing of personal information with members of the scheme or debt collectors relating to the defaulters in terms of levy payments of members who have failed to adhere to this or who have failed to adhere to the scheme rules will not require members' consent. That's very interesting to me when it comes to this specifically, because personal information, like we've already said, contains financial history information. So now they've made the specific exclusion when it comes to financial information and the payment of levies, that consent is not required to share internally with members, perhaps at the AGM or the SGM, with regards to those defaulters or parties who have breached certain rules in the scheme. So consent is not required in an instance like this. And this is very nice because it has obviously provided that protection in terms of the CSOS directive. Now, Zerlinda, perhaps I can call on you just to give an explanation, because you said it so well, of perhaps CSOS contravening their own position here and perhaps stepping a little bit over the boundaries of what they're allowed to do in terms of the CSOS Act.
Yeah, so we were chatting about it earlier, and for those of you that have been on a few of our webinars will know that at the beginning of the year, a few of us approached the DA for assistance in regard to, dealing with some of our issues and concerns relating to the CSOS. And as part of that, and with the assistance of quite a few people in the industry, this practice directive came about. And interestingly, when you look at the Community Schemes Ombuds Service Act and what a practice directive is, it is actually supposed to be like the Registrar of Deeds interpretation notes. So in other words, saying, this is what the Community Schemes Ombuds Service Act says in black and white. This is how we're actually going to, in practice, apply it. So it should be the payments of levies, the issuing of invoices, the issuing of reference numbers, what each ground in terms of Section 39 of the Praise of Relief actually mean, how the applications for dispute resolution can be made, what their turnaround times are, things to interpret and add to the Community Schemes Ombuds Service Act. However, what it has turned out to be, first and foremost, it's been an interpretation or even sometimes an amendment of the Sectional Title Schemes Management Act, an amendment of the Community Schemes Ombuds Service Act, and now it is seen almost as a regulation to POPI and PIA and the PPA. In other words, it has taken the place of the legislature, the president, in actually amending legislation. So it has, in our opinion, most certainly overstepped the mark. We believe that half of the practice directives that have been issued is not valid, it's not legal, because it is trying to step into the shoes of the legislation. You'll also notice whenever a practice directive is issued, it says that it does not amend the Community Schemes Ombuds Service Act, but in its wording, it is amending other pieces of legislation. So that's very, very concerning. And what you're going to be talking about, well, what you did mention, the POPI manuals in each case. Number one, there is no such thing as a POPI manual. And number two, in terms of the POPI legislation, it only needs to be submitted to the information regulator. Actually, no, I lie. Only the PIA manuals have to be submitted to the information regulator. The POPI manual is supposed to be kept in one of your filing cabinets, if you still have filing cabinets. So it's not supposed to be approved by the members or submitted anywhere. And yet the practice directives tell us that it has to be. So, yeah.
Thanks, Verona. And that's sort of a good stopping point. I believe you had a discussion with a client as well with regards to the, let's call it acceptance of that POPI manual. Let's do it that way today. And that must happen at an SGM. So the POPI manual is going to have to include policies and procedures relating to the processing of personal information, but it must be done in terms of this practice directive. They've also given a time period of 6 months from the practice directive, which wasn't included in the legislation. So it's not an interpretative aspect. It's actually just a direction. You need to go and do this. That it is very possible that, or rather, it says that that policy manual, that POPI manual, needs to be approved by the members at an SGM. So yeah, interesting stuff when it comes to this grey area.
We've also heard through the grapevine, and Nicole corrected me on the sidelines, that the POPI legislation actually says that the PIA manual has to be submitted to the Human Rights Commission, not the Information Regulator. So even the Information Regulator is added in their own 2 cents. Now, I've heard through the grapevine that when the practice directive came out, the Information Regulator wasn't too happy about it. And interestingly, CSOS had quite a bit of engagements with the Information Regulator. At least they told us that they did. So it's going to be an interesting time seeing how this practice directive is being dealt with. It's
most certainly. Zelina, perhaps it's just also a good stopping point. You mentioned that you are going to have a number of clients as well as external service providers provide comment back on this, and we'll do a directed effort to CSOS to speak to them specifically about this and amendment. I mean, it's not set in stone. We need to have it changed.
100%.
Excellent. Thank you so much. Okay. So like we said, 6 months POPI manual needs to be done for every single scheme. Okay. Now, the rest of the practice manual dealing with this, I'm going to go through it a little bit, but just note that it does really just speak to POPI. It speaks to security safeguards, what the information officer needs to do, which we are going to go through right now as well. But basically, it's just ensuring the safeguards that POPI has set out for those individual schemes details. Now, an interesting one just with regards to 4.8 in terms of this as well. It says that a member of the scheme shall not be entitled to access members' personal information without their consent, other than information readily available in terms of the governance or management or affairs of that scheme. Now, they've created new definitions here, readily available. What does that even mean in context with this practice directive? Readily available could be the documentation that we've got in terms of your prescribed management rule 27. But my interpretation of this is everything that's contained in 27 is not required to get consent from the individual parties by way of their membership. Like we said, in terms of section 4.4, they've already consented to their personal information being shared. It can just not be shared more than what is required. So an example of this would be, let's say, for example, a member of a scheme requires email addresses for a resolution that needs to be passed. And he sent that through to the trustees, to the managing agency. Sorry, Edna, yes, tenants would be included as this. By way of the occupation of the units in terms of section 4.4 as well. They request contact information, email addresses specifically on the parties or members of the scheme to pass this resolution. The managing agency, the scheme, sends out an Excel spreadsheet with the members' information, their work details, work contact information, next of kin details, dog information, whatever you've got on this person, and they send it in an Excel spreadsheet. Now, that's obviously not allowed because that is other personal information that's not required in terms of that specific request that that party has made, and a reasonable request at that. that that party has made for the specific reason of the resolution. Now, that's obviously not allowed, but the email addresses and contact information, if it is required in terms of the Sectional Title Schemes Management Act, to effectively give conclusion to that piece of legislation, what's required, then yes, it's allowed in terms of Section 4.4. So perhaps that's just sort of a summation of that consent requirement that we've already discussed. Now, in terms of practice or prescribed management rule 27, there's obviously a lot of information that the scheme may keep. Full names, identity numbers, section addresses, telephone numbers, email or other electronic information, just going through 27. So a lot of other things also contained in 27, but we're going to keep it to that limitation. The reason being is that obviously that relates to personal information of that data subject. Now, in terms, once again, of section 4.50 of the practice directive, it states, all the information in 4.14 above, which is basically prescribed management rule 27, is classified as personal information in terms of POPI, and their consent must be obtained from the data subject before the personal information is transmitted to a third party. And third party is capitalized, but they don't have a definition of third party. So it's the definition of third party in terms of POPI, which would be basically any third party that has a legitimate interest into the information. And these are the exemptions of 18.4 and 38. I'm not going to go through 18.4 and 38. It really does deal with, we could possibly sort of touch on it, but before I get into that, I'm going to leave that. It's actually way too granular going into that. But there are certain exemptions in terms of 18 and 38. But now what they've done in section 4.15 is said consent is required. Now, what consent is required? Is it the consent spoken about in section 4.4 when it comes to the deemed or tacit consent? That would be my argument, because they've already contained that in section 4.4 that there is deemed consent to share that personal information to the members or to a third party. I would suggest, and that argument can be made, that as a result of 4.4, that consent has already been given tacitly by the individual members to be shared internally or to specific third parties. Then relating to your information officer. Your information officer is obviously required in terms of POPI. You need to register this person with the information regulator. Something interesting that's come out of these practice directives is previously with the information regulator, we had a number of estate agencies and managing agencies really struggling with CSOS because you could only register one person once for a specific responsible party. They have now changed this online that one person can register as more than one information officer on specific schemes. So it is very possible that the managing agent, in terms of these practice directives, as well as what we've known previously, can register as the information officer of the scheme. In terms of POPI, it's supposed to be senior management level that is supposed to be registered. But in terms of this practice directive, it's taken a little bit further if you read through section 5, that the managing agency, as well as the individual directors, trustees, can actually go and register directly with POPI. Further, regulation 4, and I think this is the most important one, dealing with what you need to do as a scheme to be compliant, is that they need to have a compliance framework, which is basically your POPI manual. A personal information impact assessment is done to ensure that adequate measures are put in place. Now, this is a very good stopping point. A personal information impact assessment is your first port of call that needs to occur as a scheme and as a managing agency that you actually need to go through. There are a number of toolkits that people have put together to get compliant with your personal information impact assessment. Michelson's has a toolkit that they take individual clients through, which is a great toolkit. TPN has a POPI portal that includes a personal information impact assessment, as well as all the policies and procedures required. I'm not sure about the pricing, but it was around about R1,000 per year that you can actually do your personal information impact assessment and keep those updated, and everything's online from that side as well. So there's a number of ways to actually go about this, your personal information impact assessment and your policies, without spending an exorbitant amount on attorneys drafting very specific policies and procedures that actually needs to go and get filed. Then you need to have your PIA manual, and you need to submit that to the HRC. Internal measures are developed together with adequate systems. So that's basically talking about your cybersecurity systems that need to be put in place and how you're storing information. Your file 13 at the bottom of your desk and storing all your personal information over there without a lock and key with an open office. And then internal awareness training. So basically you need to take people through internal awareness training. That basically brings us to the end of the discussion on POPI. There's not a lot more contained in terms of these practice directives that everybody doesn't know. It speaks about the information officers, what information may be accessed, etc. The election of trustees, whatever it might be, trustees not needing to give their consent. Once again, it's that tacit consent as a result of a party being a trustee or a member at least of that specific scheme. So Zerlinda, should we take questions now specifically on this, or should we head into the PPRA discussion? I see we're actually running out of time because we're already 50 minutes.
I'm going to be taking note of all the comments and all the questions and sending them through to you if you don't mind answering them, and then we can post them with the recording. So perhaps we can talk about the PPRA, and then when we have some time left, we can deal with questions. Is that okay?
That's 100% perfect. I'm only going to get to them after your leave in February.
That's fine.
Okay. So the PPRA has created quite a substantial amount of gray area as well. I hate the term gray area, but we're using it a lot today. The reason being is that the definition of estate agent to property practitioner has now included 11 different industries that weren't previously included in the definition of an estate agent, of your traditional estate agency, your rental, and your sales specialists. Managing agents now do fall under this definition, and we have had a very stern conversation at the NAMA conference by the PPRA that we are certainly included in the definition of managing agent, even though there is no true definition of managing agent in terms of the Act. So you will need to be PPRA compliant. This means that as a business property practitioner, you will need to be PPRA compliant, as well as individuals practicing in certain responsibilities at the managing agent would need to register. Now, I'm going to give you a little bit of advice on this. Speak to the PPRA. I know it might seem as if certain government institutions don't get back to you. They might not right away, but they have been very collaboratory with a number of the industry players regarding what they should and what they shouldn't do. NAMA is in constant communication with the PPRA as well. I believe they have set out or tried to at least get industry exemption for a period of 3 years, which I'm not sure is going to be granted. I personally believe it might not, but that's just my own personal opinion when it comes to this. The reason being is I think that they want the individual estate agencies rather, or managing agents at least, to do their own exemption applications in terms of Section 4. The reason why we are doing exemption applications in terms of Section 4 is because in terms of the Property Practitioners Act, a person needs to register and have a Fidelity Fund certificate that is valid for a period of 3 years. But technically, in terms of the legislation, it is impossible to register. The reason being is that you have not done a NQF 4 or 5 qualification, depending on the individual standing, whether they're a director or a principal or candidate, whatever it might be, because none of those NQF or SAQA qualifications have actually been created. So it's impossible to get the qualification that relates specifically to property management. It's also impossible to get your CPD verification points because none of it has been created. Your logbooking, as well as the registration of a, let's call it managing agency, can also not be done online through the PPRA's website because they only have categories valid for estate agents. So it's actually pretty impossible to do so, even though they have directed everybody to do so at this point in time, or at least seek exemption. So here is my 2 top tips for the PPRA. deal with them directly, send them an email. Send Delhi or Advocate Deborah Val an email. Send their compliance officers, their training educators, whatever it might be, an email. If you're in Johannesburg, set up a meeting. If you're not, set up a Zoom meeting with them, discuss your individual requirements, and then seek exemption directly through Section 4. There's a very specific prescribed form that they will provide to you that you can go out and be incredibly granular with the form that relates to the individual parties who are busy working for you and what their responsibilities are, because at the end of the day, you don't want to be registering everyone. Remember, it's already 2,350 Rand for registration of a candidate at this point in time for your FFC. So it's quite a lot. And if everybody needs to register through that process, then obviously it's a lot, but you can get very granular. So you can get an exclusion on a specific basis that relates to your business and the responsibilities that that party has undertaken, or you can do a business exemption. They're not going to grant these for 3 years. They've already indicated that to us. They're going to grant it for 6 months and then possibly renew after another 6 months. They might grant it for 18 months, but that's basically the maximum you're sitting with. So engage with the PPRA, get those forms that you need to go and complete your own Excel schedule of persons working for you and what their rights and responsibilities, or rather roles and responsibilities are, and then go about it that way. But it's better to at least try and attempt to do so now than you sitting with a scenario a year down the line where they do send you a compliance note for not complying. So I'd just suggest make contact with them, speak to them. They have been very collaboratory, like I've said, with the industry, even though a lot of this has not yet been done. Perhaps a good stopping point over here. Just like, not like the CSOS practice directives, because CSOS actually drafted these. With the Property Practitioners Act, the PPRA had no hand in drafting it. It's the legislature that drafts this. It's the people in Parliament that goes and implements this and signs it into legislation. So as much as the frustration might be with the regulatory body, remember that they also only just trying to do a job of regulation and interpretation of that piece of legislation. We can be angry at the legislature, we can't be angry at the PPRA. They're only trying to do their job with, unfortunately, the sort of poison chalice position that they've been put into currently with trying to interpret something and regulate it to 11 different industries. However, we can all be angry at CSOS. I'm joking. Okay. We can all try and collaborate and try and get them to amend these practice directives to assist us as an industry rather than putting a barrier in place for business. So Linda, that is the end of my formal presentation. I'm sure if there are questions, you're more than welcome to ask those.
Fantastic. Peter, thank you so much. You'll see, everybody, that the chat function is quite active, both with questions and with information that we've popped on there. So Trafalgar's website is incredibly useful. I've posted a couple of my favorites links and a couple of my favorite people's contact information as well. Corinne and Daniela and yourself, Peter. So I'm sure everybody online can contact you directly. And then, of course, your training material on your website as well. I can honestly say that all of our team have done the courses, and I've put all my building managers on it as well. And if anybody's ever looking for nice comprehensive training, both for trustees, owners, building managers, caretakers, I've put that on. Corinne commented on the chat function as well that it's all inclusive. In other words, other managing agents can share in your training as well, which is fantastic. It's always very difficult, offering these types of services as a managing agent. But of course, we all do need to work together to improve the industry, most certainly. So we do have quite a few questions that have come through. Yeah, I'm going to start from the bottom up, actually. It says, our managing agent and I was listed last year as the information officer, as I was a trustee. New trustees in place since 2021. What recourse do I have to find out if new trustees have changed and removed me as listed, nobody coming back to me? So in other words, just to find out who is actually registered as the information officer. Would that just to be contacting the information regulator directly?
Exactly. Yes, 100%. And you can do so online as well.
Okay, perfect. Here's another one. How does the POPI Act relate to the use of CCTV cameras enclosed in areas like an elevator where it was installed without having the necessary compliance in terms of the prescribed management rules, obviously improvements to common property and all of those fun things. Although the cameras are also installed at the building entrances and exits, there seems to be no justification for the installation in the lift. That's an interesting one. I've actually come across it quite often. Do you have any comments there with regards to POPI and CCTV cameras?
Yeah, most certainly. So I'm not going to deal with the Sectional Title Schemes Management Act portion. Everybody knows that already. But with regards to POPI, notification is vital. So that's transparency and openness. So 2 considerations here. You need to put up disclaimers that there are CCTV cameras. So everybody needs to know that those CCTV cameras are there. And number 2, safeguarding of that information, because it's considered biometric information. So how you're storing it, where you're storing it, what servers are being used, how is that actually being safeguarded in terms of that is vitally important. So just actually 2 points on that, disclaimers and storage. And obviously dissemination, but yeah.
Perfect. There were a couple of questions that were posted to me directly, as well as 1 or 2 on the group, and you did deal with it, but perhaps we can just summarize it as a closing, is the issue of this practice directive now that says we need to have the this manual approved by our members. Do you think it would be a good idea in the interim for the trustees to at least circulate the manual to all of the owners, to at least let them know that it's there? I mean, of course, in many instances, we place it on our websites, and therefore that's publication. But many schemes don't have those types of platforms. So would it be advisable to at least notify the owners, or would you advise the body corporates that perhaps have annual general meetings or special general meetings coming up to add it to the agenda? What would you advise them?
Both. Do both. I mean, you can't be overly compliant. There's no such thing. So add it to the agenda, as well as sending it out directly to the members would be great.
Okay. We've had a couple of questions for the contact details of the relevant parties at the PPRA. So we'll put that together, and Peter, I'll send you all the comments and questions that were on the chat function as well. Obviously, POPI compliant and all of those fun things. We don't want to get ourselves into trouble. Ladies and gentlemen, thank you so much for joining us today. I do have a couple of minutes afterwards to stay online if anybody wishes to raise some questions. Peter, do you have 10 or so minutes? Or
I've got half an hour if you like. No problem.
Perfect. Fantastic stuff. So ladies and gents, I'm going to open up the floor to those of you that have any comments or questions, compliments to Peter. Those are always welcome. For those of you that aren't able to stay any longer, thank you so much for joining us. We'll end the recording here, but of course, if you would like to stay online just to chat to us a little bit more, you are more than welcome. Just remember to unmute yourself, and then we can have a bit of a chat. Leanne, are you still online?
Hi, Zelinda, I'm yes.
Hi. So Peter, I'm sure that you saw quite a few of the webinars and articles and things like that Leanne has done for us. She was very interested to join today. I don't know if you guys know each other in the industry, but she's our PPA and POPI and PIA and ABC and EEFG, whatever expert that we always use. And I'm looking forward to perhaps another joint webinar or a live session or something like that we can invite you to. Leanne, do you have any comments or questions for Peter?
My one question was,